Hello and welcome everyone today on our webinar for 5 Steps to an Effective Estate Plan. I'm Bailey Kasum, the financial advisor here in Terrace, and I'm joined by Alyssa Mitha, Director of Tax and Estate Planning at Mackenzie Investments. This webinar will be recorded and available for viewing at a later date. And we will have a question and answer period at the end. So if you have any questions throughout the presentation, please just throw them in the chat. Just wanted to start off by recognizing and acknowledging the First Nation traditional territories under which our service area falls. Northern Savings Credit Union's 4 branches operate in the following communities: Masset, Dajianguides, Prince Rupert, and Terrace. Therefore, we acknowledge the traditional unceded lands of the Haida people and the traditional territories of the Tsimshian Nation. Just wanted to briefly introduce our financial planning and wellness team. We have Jackie Touche, the financial advisor and wealth leader in the Prince Rupert branch, joined by our assistant, Amy Alamersh, and Tina Davenport, the financial services representative. Here in the Terrace office, we have myself and Tia Buer as financial advisors. Our financial planning services that we offer to our members and clients include retirement planning, insurance planning, education planning, tax planning, and estate planning. Just a brief introduction on our guest speaker today, Alyssa Mitha. She's the Director of Tax and Estate Planning at Mackenzie Investments, located in the Calgary office. She works primarily with the sales teams in Alberta, British Columbia, and Saskatchewan, providing support to the lead of sales of Mackenzie and company-related products and services. Her expertise is in the area of estate planning, and she assists advisors with any tax and estate planning inquiries. Prior to joining Mackenzie, Alyssa worked at a national leading trust company in a similar role. She has also previously worked in a private practice as an estate planning and probate lawyer for a number of years. Everyone, please welcome Alyssa.
Thanks, Bailey, for the introduction. I'm just going to share my screen here so you guys can see the presentation we have. Is everyone able to see that okay?
Looks good.
Okay, perfect. Thanks, Bailey. So I'm really excited to do this presentation. 5 Steps to an Effective Estate Plan is just a really great introduction to estate planning for beginners. But for those of you who have your estate planning in order, it's also really helpful. I hope this acts as a way for you to be able to check in and see if your planning is up to date. I think everyone will be able to get something out of this presentation. And like Bailey said, we're happy to answer any questions at the end. So this is just our standard disclaimer. So although I'm an estate planning lawyer, nothing I say should be construed as tax or legal advice. We're having a general discussion today. So I'll just do a high level summary here of the 5 steps that we're going to be discussing, and then we'll kind of go through each of them in detail. The bulk of this presentation is going to be in the first 2 steps. So to start off with, the first one is working with your advisor to set realistic goals, and that could be ways to make your planning more tax effective. It could also be determining the best way for you to be able to distribute your assets. Whatever your goals are, you want to just work with your advisors, ensure that you let them know so that they're able to craft a plan for you. A lot of people don't get their estate planning done just because they're so worried about not knowing what they want to do or what their options are. But the first step is just working with your advisors, letting them know what your goals are, and then it's their job to help come up with a plan and give you some options. The second step is considering which tools fit your situation. So that could be your estate planning documents, your will, your powers of attorney. It could also include things like life insurance. So we're going to go over those tools in detail. The third one is choosing the people who you would like to speak for you. So while you're alive, but if you became incapacitated, who would you want to make those financial decisions on your behalf? Who would you want to make healthcare decisions for you? Once you've passed away, you appoint an executor in your will, and that person is essentially administering your estate and making those decisions for you once you've passed away. You might have a trustee in there who's given discretionary powers, and they're able to distribute your assets based on the recommendation you've provided for them or the terms that are in the trust. Number 4 is communicating your wishes. So the best thing you can do is let the people let the people who you've appointed know that you've appointed them. A lot of people will have a will done, they'll appoint an executor, they won't let them know that they've appointed them as executor, and that can be really problematic. Other people will have their estate planning done, but they won't let their beneficiaries know who has drafted the will, where the will is being stored. So essentially communicating your wishes, letting the people know that you've appointed them, what your funeral wishes are. And then the last one is keeping your plan up to date. So even if you have your estate planning in order, are you doing a review of it? Typically, a person should be reviewing their documents every 3 to 5 years. But if there's a major life event that's happened, like death in a family or divorce, that's a big reason why you would want to look at your plan and ensure that it's still up to date. So let's talk about step number 1 first. I'll just pull up all of these points so we can discuss them. So the first one is minimizing taxes. So when you pass away, there's a deemed disposition of all of your assets. If you're married, you essentially want all of your assets to roll over to the surviving spouse. So you want to ensure that they're named on all of your registered investments. You want to ensure that your assets are joint so that there's an automatic rollover to the spouse. We'll talk a little bit later about the probate process, but essentially you want to avoid probate until the death of the surviving spouse. If everything's going to your spouse, there's no reason why probate should take place twice. So you want to ensure that you're able to minimize taxes by having that rollover. The second thing you want to do is ensure that you're transferring assets to beneficiaries in a fair and efficient manner. Fair doesn't necessarily mean equal. So if you have someone who's lived at home with you, a child that's been with you, they've looked after you, perhaps you want to leave them the house, maybe you want to leave them a little bit more for the sacrifices they've made. If you have a child that's really involved with a business, perhaps you want to leave them shares of the business, and that might not equal to a completely even distribution. So you have to kind of come up with what your goals are and then work with your advisors to ensure that they know what your understanding is and they can help come up with ways to maybe equalize the estate a little bit more or give you ideas to provide for a more fair distribution. The third one is providing for your survivors. So this could be your children. It could also be nieces and nephews. If you have someone in your family that has a disability and you've been providing for them, perhaps you want to still provide for them once you've passed away. The next one is ensuring business continuity. So again, you kind of have to make the decision. Do you have family members that are involved with the business? Do you want to leave those shares to them? Is it something where they should be purchasing the shares, or are you gifting the shares? If you don't want it to continue within the family or there's no successor in the family who can take it over, is there a third party that you would want to acquire the shares first? So that's a big part of the estate plan and business succession plan, but maybe you also need to have a shareholder agreement in place so that that can be dealt with now. That shareholder agreement is going to act like a roadmap. So it's really important that if you have business assets, that you have something like a shareholder agreement in place. And then the next one is something that is really difficult, and I think it's a big reason why people delay their estate planning, and that is identifying who should be looking after your minor children. So when I was in private practice, we used to give out an estate planning questionnaire. It would have all of these questions, and that way, when clients came into the meeting, they've had an opportunity to kind of think about what they want to do. And I noticed a lot of clients would end up canceling this appointment or they would delay it. Um, and then I had a client who came in and said after our call, like, I wish you guys didn't hand out this estate planning questionnaire because it's really difficult for me when I was trying to think about what I wanted to do and how I wanted to distribute the estate and, what I could do as far as my minor children go and setting up trusts. It's just something that I didn't know what I was able to do. I didn't know what my options are. But now that we've sat down and you've kind of explained it to me, it's much easier. So we stopped passing out this questionnaire. So the point I'm trying to make here is, if this is something that you have difficulty with, if any of these points are things that you've thought about, but you just don't know what your options are, maybe it's best you talk to your advisors first and figure out what the options are. You don't have to do this alone. You don't have to kind of be on an island thinking about these things. There's a lot of good options. And so, the first step is just meeting with your advisors to discuss it. But as far as this one goes in particular, you want to kind of start thinking about who you would want to look after your children if anything was to happen to you. And a lot of people are like, oh, well, obviously my surviving spouse would look after the kids, but what if something was to happen to both of you at the same time? And if you're divorced, maybe you guys are going to name different people. Um, and so, you might want to talk to your former spouse and kind of get on the same page that if something were to happen to both of you, um, who would you want to look after those kids? As far as transferring assets to beneficiaries, just some other options. So a lot of people will get life insurance to liquidate or to cause or to allow for more liquidity in the estate. So say for instance, your main asset was your home and you wanted to leave your home to one of your children. Who would pay for the debts? Who would pay for any liabilities? Who would pay for the taxes? And then how do you pay out the other beneficiaries? So life insurance is a common tool. Same thing with if you're leaving certain children business assets, how are you going to provide for the other children who are not involved in the business? Life insurance is a good tool. As far as registered plans, again, we're going to talk about it a little bit more in a second, but having beneficiaries is key. A lot of people will think about gifting while they're alive, and that's a good option, right? You get to see your beneficiaries enjoy those assets while you're still living. The only thing I would worry about in that situation is you want to ensure that you have enough assets to cover you for your lifetime. So I've seen situations in private practice where people will start gifting and then they go through some sort of health condition, they're no longer able to live at home and now they're living in a care home. Those care homes can be really expensive, so you just want to ensure that you have enough and you're not gifting too early. And then we'll talk a little bit more about joint ownership later in the presentation. But like I said, between spouses, it's really important. You want to keep those assets joint for the most part, unless there's a reason why, like if you have a prenup in place or there's other documentation as to why you don't want a joint ownership. But for the most part, between spouses, that's a common planning technique. So as far as registered plans with RSPs and RIFs, naming a beneficiary is really important, especially in a province like BC where there's a probate tax. So I'm in Alberta where it's a flat fee probate tax of $525. In provinces like BC and Ontario where it's higher, we want to do some probate planning. So you want to ensure that your assets have named beneficiaries. So say for instance, your RSP didn't have a named beneficiary and now falls into your estate, which is fine if you have a will. It'll be distributed as per the terms of your will. But now not only do you have to pay the 1.4% probate tax, it delays the distribution of that asset. The second big one is RESP succession planning. So a lot of wills won't talk about an RESP. So if you were a subscriber to an RESP, you want to ensure that your will discusses that. Because your will is what's going to name a successor subscriber. So you don't want that RESP to necessarily collapse on your death. So you want to discuss it in the will, and the way to do that is to name someone in the will. You can also provide other provisions like when the RESP is to collapse, confirmation that your estate is able to continue to contribute to the RESP. So that's really important. I would go and review your will and just ensure that there's language in there. And then the last one here is TFSA succession planning. So you want to ensure that you're naming your spouse as a successor holder to the account. If you don't have a spouse, then you want to ensure that you have a beneficiary named, again, so that it falls outside of the estate. And we'll talk a little bit more about TFSAs right now. So if you look at this chart over here, we have a TFSA start date of 2009, right? And a date of death of 2019. So 10 years, we can see that in that 10-year period, there's tax-free growth for that TFSA. Now, this is where it gets a little bit trickier. So from date of death until distribution date, that 1-year period, if you've named a successor subscriber, that growth is tax-free. And there's no, TFSA contribution room needed for a spouse. So that's really important. You want to ensure that for spouses, you've named a successor. And then, of course, for anyone else, again, you want to ensure that you have a named beneficiary for your TFSA. Okay, so we'll talk a little bit here about the probate process. Some of you might be familiar with it, others might not. But essentially, it's confirmation by the courts that there's a valid will, and they're granting the executor with a certificate to be able to act. So if you think about it, if you had a sibling that passed away, there's a will and you've been named the executor, and let's say the sister had $100,000 with RBC. If the executor was to go to RBC and say, here's the will and here's a death certificate, I'm the named executor, can you release the proceeds to me so I can pay out the beneficiaries? RBC is going to say, well, no, like we don't know if this is a valid will, and they don't want the liability, right, for releasing those proceeds. So that's why probate exists. It's essentially this process where the court is confirming the executor is the person they say they are, all the beneficiaries have been served, this is a valid will, and that way all the institutions don't have to worry about this liability aspect. Now, with that probate process, it's a little bit different per province. But the courts take a fee, and that's the probate fee. We're going to talk about how that's calculated. So it's based on the value of the deceased estate, and it's going to include non-registered stocks, bonds, mutual funds, real estate minus the mortgage, jewelry, vehicles, and then registered investments and life insurance where there's no beneficiary and it's payable to the estate. It's not going to include, again, the mortgages and then registered investments and life insurance where there is a named beneficiary. And it's also not going to include jointly owned assets where there's a right of survivorship. So over here is a breakdown of the fees. So you can see anything less than $25,000, there's no fee. Between $25,000 and $50,000, it's 0.6 of 1%. And then anything over $50,000, it's 1.4%. So, it's unfortunate that these fees exist. Like I said, in Alberta, it's something that we don't have to worry about. But in other provinces, we do have to do a little bit of probate planning. Having said that, though, you don't want to start just transferring assets to avoid probate. So certain things are okay. Like I said, naming beneficiaries on registered investments is a good one. It falls outside of the estate. They get that asset immediately, and you don't pay the 1.4% on it. Same thing with life insurance and jointly owned assets. But a lot of times clients will start adding adult children on title to property, and that could be more problematic. If they already have assets, now you're looking at capital gains. And the other thing is, if your children are going through matrimonial issues, now there's an asset where there's joint ownership. Creditors are now are able to come after that asset because there's joint ownership. So you want to be careful with that. With spouses, it's always okay. But with adult children, it's really you want to have caution before doing that. You want to ensure that you're talking to your lawyers and accountants to ensure that there's no issues there. You could also transfer assets into a living trust. With that, again, you want to get advice. They're expensive to set up. They're also taxed at a top rate. So it can be an option, but you want to talk to a lawyer and ensure that it makes sense in your situation. Securing debt with real estate, and then again, gifting before death. And like I said, that's a great option, but we just want to ensure that you have enough in your estate to cover you for your lifetime, because unexpected things could come up. And like I said, care homes are really expensive. So you want to ensure that you have proper care for the rest of your life before you start gifting. And the big thing here is probate planning should be considered, right? Where we can avoid the probate tax, we should, but it shouldn't compromise your true wishes. You don't want to start, adding children on title to property and things like that without getting the proper advice. So I just want to talk a little bit about how property is owned so you kind of have a better idea of how it works. So tenancy in common is typically in a situation where, let's say you have a brother and sister, they buy a property together. It's likely that they each own an interest in the property, right? So 40-60 or 50-50, they each have their own interest. If one of them was to pass away, let's say the brother passes away, his 50% is going to be passed down to his estate, and then the sister's 50% would be passed down to her estate. So there's no right of survivorship here. They each own an interest in the property. True joint tenancy is usually a situation where you have husband and wife. They own the property jointly with the right of survivorship. So if husband passes away, the wife automatically acquires the property, or vice versa. Again, very common between spouses, less common between spouses and children. And then you have this thing called a resulting trust joint tenancy. And this is a situation where, let's say we have um, someone who's elderly and they decide to add their adult child onto, let's say, a bank account. So the presumption here is that the child is just added to the bank account to help pay for bills, to make things a little bit easier. She has access to those accounts as like a trustee, but she's not entitled to the proceeds. The parent still wants that asset to form part of her estate when she passes away. Let's say she has 3 kids, she wants it to be divided equally between the 3 kids. That adult child is just there for convenience purposes. The law is going to presume when you're adding an adult child um, as an owner to an account or to property, that they're just there for convenience purposes and it's not their asset. So that's this resulting trust joint tenancy. Technically, in situations like this, because there's no true ownership, no true beneficial ownership of that adult child, it should form part of the estate and go through probate. Practically speaking, like some lawyers will say, you know what, we can transfer the asset without probate, but truly it is an asset that should go through probate. And there's new reporting rules for things like this. So it's called a bare trust arrangement. So now you should be reporting these sorts of accounts to the CRA. The account would have to be over $50,000. Otherwise, it's exempt. You don't have to report it. But this is something new that's kind of come up recently. So resulting trust joint tenancies can be a good option, but now with the reporting requirements, some people might not be comfortable with that. Perhaps instead of having this sort of arrangement, they appoint their adult child as a power of attorney, and as power of attorney, they have access to the account. So something to think about and something to talk to your advisor about. So as far as the second step here goes, we're going to talk about the different estate planning tools that you might want to consider. So first off, everyone should have a will. Only about 51% of Canadians have a will. And a lot of them will say, I don't have enough assets, I'm too young. And none of that's true. Like if you have a bank account over $10,000, you need to have a will. The bank isn't going to transfer that asset to anyone without probate. And probate without a will is a lot more expensive. It's a lot more time consuming. The lawyer has to fill out a lot more paperwork. So that's going to increase the cost. So a will is really important. If you have adult children, I would also recommend that you talk to them about getting a will. I know when I was in private practice, it wasn't uncommon for people to start gifting like a will for a birthday. They would make an appointment and say, hey, my kid wants to come in, get their will done. I'm going to cover it, just so that it's incentive for the kids to get it done. So something to think about. A trust can be a living trust, or it can be a testamentary trust, which is a trust provided for in the will. I would say about 70% of the wills that I drafted had some sort of trust component in there. So a lot of people will do age trusts. They're not comfortable with their children receiving funds outright at 18. So maybe they set up a trust in there where the beneficiary receives half the money at 25, the balance at 35, and there's a discretionary component in there. So you can say my trustee can release proceeds if my child wants to buy a house as a down payment, if they're getting married, if they need to buy a vehicle, education, things like that. Powers of attorney are really important. There's one for financial decisions and there's one for healthcare decisions. These typically come into effect while you're alive but incapable. So they're really important to get done. A lot of lawyers will offer some sort of package with the wills and powers of attorney. I recommend getting all of those documents drafted. There's also a healthcare directive where you're able to say what your healthcare wishes are. That's really important as well. Life insurance, like I said, is a good one to help provide for some liquidity in the estate to cover taxes, debts, to pay off some of the beneficiaries that you're not giving direct assets to. Organ donation in BC is pretty simple now. You're able to do it online. You can just register online. So that if that's something you're interested in doing, you're now able to do it quite easily. It wasn't like that a few years ago, so I'm glad that they've changed that. As far as business succession planning goes, again, even from now, I would highly recommend getting a shareholder agreement if you don't have one. That's something that you should be thinking about. And then lastly, funeral arrangements. So these days, pre-planned funerals are very common. You have to remember the first thing that the executor is going to have to do is plan your funeral. Um, and usually they're very emotional at that time. Um, it's very difficult if they don't know what you want. If your children don't know what your wishes are, do you want to be buried? Do you want to be cremated? Do you want a celebration of life? If they have instructions on that, it's a lot simpler. You can have those conversations now. A lot of clients will also do what's called a letter of wishes, where they'll write it down and keep it with a copy of the will. So that's something to think about as well if you don't want to have that conversation, but you want your kids to know what your wishes are. So what happens if you pass away without a will? A lot of people think the government just gets your money. That's not the case. There is a provincially regulated schedule. Um, it's just you don't really want the province to dictate how your assets should be distributed, right? But this is what would happen. So if there's a spouse and children, the spouse is going to get the household furnishings in the first $300,000, and then the remainder is going to be split equally, 50% going to the spouse and 50% being divided between the children. If the children are from a deceased previous relationship, then that $300,000 is reduced down to 150. If there's no spouse but there's children, the children split the estate equally. Say one of the children has predeceased the parents, then it would be distributed to that child's children, so their heirs. If no spouse, no children, then you have a priority order of parents, then siblings, then grandparents, then siblings of parents and cousins, and it keeps kind of going from there. I think for single people or people who don't have children, it's all the more reason to get your will done, right? You might have nieces and nephews that you don't even have a relationship with. Perhaps you'd rather have charity um, receive those assets. So you really want to ensure that your planning is done. The other thing I want to mention is when I say spouse, because this differs from province to province, um, the legislation in BC counts spouses as married people who are living in a marriage-like relationship for for at least 2 years. Um, so that's something to keep in mind too. There are provinces that don't give common law spouses property rights, but here in BC they do. So as far as planning a will goes, we've talked about a lot of these things, but essentially beneficiaries are the people who are receiving your estate assets. So they're the ones that are receiving the inheritance. Executor would be the person who is administering your estate. They're completing all of those tasks. So that could be, liquidating all of your assets, um, preparing all the documentation for beneficiaries to sign, actually doing that distribution. A simple estate honestly has between 30 to 40 estate administration tasks. We're going to provide you with a checklist that Mackenzie has that kind of outlines all of those things. So it's something that you might want to talk to your executor about. Um, and if you're deciding who to appoint after looking at the list, it might help give you a better idea. Usually you want to appoint someone who has the time and someone who's financially savvy. If you don't have anyone, you might want to talk about appointing your lawyer or accountant, but if they're the same age as you should at least have an alternate in place. Trust companies are another common option, so something to think about. Your guardians for minor children. If you want to leave any assets to charity, that's something you can provide for in your will. And then again, setting up testamentary trust. And that could be for a variety of reasons. We touched the age trust. If you have anybody in your family that has a disability that you're providing for, it's very important to have a trust set up for them. You don't want them kicked off of their social assistance benefits. So you want to talk to your lawyer about that. If you have anyone who has substance abuse issues, maybe you want to ensure that they get drug tested before they receive any inheritance. You can include that in there. Spendthrifts, those are common reasons to set up a trust. So again, it provides for delayed distribution of the assets. The trustee is going to retain control while that trust exists. Choosing the people you would like to speak for you. So in your will, it's going to be the executor. In your powers of attorney, you're going to have your power of attorney for property. So someone who's making financial decisions on your behalf, they're pretty much able to do almost everything you're able to do. They can go through your bank account, sell your property. So you want to appoint someone who you fully trust. You can put restrictions in there if you would like. You don't have to keep it so open-ended, but for the most part, you don't want to put too many restrictions. You really want to focus on appointing someone you trust, someone to make your healthcare decisions for you. Those are kind of the three big ones. The next one is communicating your wishes. So like I said, that letter of wishes is really common. And if you're appointing your executor, you want to let them know you've appointed them. You should be asking for their permission, right? You want to appoint someone who's going to take on the responsibility. And you want to let them know who the estate planning lawyer is, where the original will is being stored. Some people will put it in a safety deposit box. If no one has access to that safety deposit box, it can become really difficult. These days, I think for the most part, a lot of law firms will store the original. If you have a safe at home, that's another good option, but you want to let your executor know where you're storing it. And then lastly, we'll talk about keeping your plan up to date. So these are, the main reasons why you would look at changing your estate planning document. So marriage, separation, and divorce, if you're going through that, that's something that you should go ahead and change your will right away. Relocation, so if you're moving out of the province, you want to get your will done. If you have assets in multiple jurisdictions, so you have assets in BC, and let's say you have a property in Florida, you should look at having multiple wills done, one in BC, one in Florida. You want to keep your lawyers informed of the wills. So the first line of all wills is I revoke all prior wills. So if you have a will done in BC, you go talk to your lawyer in Florida and have a will done there. If you don't let them know you have a will done in BC, it could revoke it. So it's really important that all of your advisors are kind of up to date on your planning. And the reason why you want to have multiple wills is that probate process, Florida is going to require the same thing. So if you have to get probate done here and you have to get probate done there, it could be like 6 months before you're able to send that will off to Florida. So it just delays things and it's quite costly. It's called a resealing process where you have one will that you have to probate in multiple jurisdictions. Few lawyers do it. That's why legal fees are high. So something to think about. Sale of a business would be another one. Inheritance. If you inherit a cabin property, you want it to stay within your family, you might not necessarily want it to go to your spouse. For that reason, you might have to do an update to your will. Children moving in and out. So you typically want to appoint an executor in the same province where you're located. So if you have a child moving to the States, you really shouldn't have them on as executor. So a reason why you might have to change your will. And then caring for aging parents. This one's becoming more and more common, right? We think that when we do a will, we're looking after the next generation, our children. But if you're looking for an elderly parent and something was to happen to you, then what happens to that parent, right? So you might want to put a bequest in your will that, the parent, if they're alive, get $250,000, or perhaps they're allowed to reside in your home for a certain period of time and your estate's going to cover those expenses. So things like that are things you want to think about. And that one especially is one where I noticed when I was in private practice, people were coming in to do updates to include something like that in there. So that's it for me. Happy to take any questions.
Thank you so much, Alyssa, for going over those 5 steps to an effective estate plan. There was a lot of great information in there. I will double check the chat and the Q&A just to make sure if anything came through. I do have a couple questions, however. What can or should be done if I have an estranged child and therefore do not want to leave any inheritance to them?
Yeah, that's a great question. So, like 10 years ago, what people would do is they would say something like, I leave $1 to that child. And the reason why they would do that is so that if it went to litigation, a judge knew that they weren't forgotten about because they've, named them and they've said this dollar bequest. I don't recommend doing that. Judges don't like to see that. And the other thing is when you pass away, whoever you listed as a beneficiary is served with that probate application. So if you have an estranged child who you have no relationship with, they might not have known when you were going to pass. And now that they've been served with the probate application, they know. It's more reason for them to commence litigation. So what you can do is at the end of the will, you can put in what's called a testator statement. And in there, you can just say, like, I don't have a relationship with this child. And that's why they've been excluded from the will. That way, a judge still knows, but they haven't been served with this notice of application.
Perfect. Thanks so much. And I just see we may have a question here. Paul, you have your hand up. I'm going to try to unmute you here if you'd like to ask a question. Paul, if you do have a question, you can unmute yourself.
Yes. I understand that an executor must be living in the same place as the will. Am I saying this the right way?
They don't have to be living in the same place, but it just makes things a lot easier.
Same
So
province, I mean.
yeah, same province. So it's best if they're living in the same province. A lot of times they have to go in person. They have to sign documents. Um, it just makes it a lot simpler. If they're out of the country, that's where it could be really problematic because the court says that um, a trust exists where management and control takes place. An estate is considered a trust. So, for tax purposes, if management and control is happening in the US because the executor lives in the US, it could cause further tax implications. So, it's best if they're in the province, but like if you only have one child and they're in Ontario, it's not going to be a huge issue. It's just going to be a lot more work. But if they're living outside of Canada, that's where it could be really problematic. So at that point, I would say have somebody else in mind other than that out of province or out of country executor, that non-resident executor.
Okay, thank you.
No worries.
Perfect. And just one last question here I have for you, Alyssa. Are online will kits a good option? I know that's I've gotten that from a lot of clients, so I figured I would ask your opinion on that.
Yeah, for sure. So cost is a big reason why people do these online will kits. You can get them for, $100, $200. I am very against them. I actually have a couple of friends who did them a couple weeks ago. And I looked at it and there were so many issues. And, if someone who doesn't look at wills all the time or, isn't used to seeing wills, when you read it, it all looks okay. You don't really understand the implications of what could happen because it just on a plain reading looks okay. So these friends wanted to leave some assets to their kids, and they wanted to set up a trust for them. And if one of the kids was to pass, they wanted their children to get their grandchildren to get their portion of the estate. And the way that the will kit did it, it didn't allow for that inheritance to fall to the next generation. It would just then go to the surviving children, and that's really problematic. And that's just one of many examples. So you're not getting legal advice with those will kits. They're just very generic. You're essentially filling out a questionnaire and it's generating this document. So I would say avoid the will kits at all costs. What I would suggest doing instead is calling law firms, seeing which law firms charge a flat fee. A lot of firms for very simple planning will charge a low rate, and it's not much more expensive than the will kits. The other thing I would ask the lawyer is if I'm going to make changes in the future, what do you charge? A lot of them will charge a minimal fee like $25. Then you have this ongoing relationship with them and you can continue to change it um, as your plans change. But the will kits, I would say definitely avoid.
Absolutely. That's some great information. Thanks, Alyssa. We did have one question come into the chat here. I will just pull it up. Grace would like to know, could you maybe elaborate a bit more on the clarification on the Bear Trust?
Yeah, for sure. So that's a really hot topic right now, just because it's a new change as far as the CRA reporting rules go. So essentially, wherever you're adding an adult child onto property, whether that be real estate or a bank account, the law is presuming that that person is just being added there as a trustee. So it's creating this bare trust arrangement. So both people will have legal ownership because they're both on title to the real estate or they're both on this joint account, but the child doesn't have beneficial ownership. Um, the child is just there as a trustee. They're not entitled to the proceeds. And CRA wants to know what type of accounts like this exist. So they're creating this reporting requirement. There's no tax implication there, but they require this new reporting. So the only way that this won't happen is if you can prove that it's a true joint asset. So say, for instance, you're adding the adult child onto the bank account and you want them to have ownership rights. They can take the money from now. That you would have to document your intention and then you don't have to report it. But any other sort of structure where you're adding an adult child just to help out or to avoid probate, things like that, that's creating this bare trust arrangement and you have to follow these new reporting rules. What I can do is someone on our team wrote a really great article and we can send that over to you, Bailey, so you can send it out to the group. And it kind of goes over it in detail and it's a great summary.
That would be great. Thanks, Alyssa.
No worries.
I believe that's all the questions we have for now. If anything comes up with anyone, please don't hesitate to reach out to a member of our team. We're happy to help. And thank you again, Alyssa, for all that great information and going over that with us.
Absolutely. Thank you.
Thanks everyone for attending our webinar today.